Hello, MTI members. This is Tom Morrison here from the national offices in Nashville, Tennessee. We're glad to see you today. Glad you're tuning in to MTI TV's live webcast to talk about the statement of limited liability and how it can protect you and your bottom lines. So before we get started I'd like to remind everybody that down to the right, you have the chat box. Post in there where you're listening from. Would like to see where members are listening from as you're listening into this conversation. So post any questions as I'll be monitoring that as Jeff and I are talking about the statement of limited liability and the issues surrounding it. And you can post questions there if you'd like, and we'll do our best to answer those questions. So a couple of things I'd like to share, just exciting things going on at MTI is this right here. One of them is the MTI app. If you get your phone, you go to your app store, you can see it here. It is a highly active app. You can go to the app store and look up MTI Connect and download it. In there, you can look up the members, you can post discussion forums. But the biggest thing that's been added in the last week is you can now watch all of the technical standards updates that happen, our quarterly webcasts on the technical standards updates with NADCAP, CQI9, AMEC, ASTM, all that stuff. You can see those videos right there on the app, as well as the number one thing you want to see is our quarterly sales forecasting webcast. Our next one's on May 31st, but you can go in there and right from the app, you can watch all the quarterly forecasts. You can see how things are going to do and see heat treating, as well as 8 different industries that drive your heat treat sales. So lots of good information on that app. So remember, go to MTI Connect at the App Store and download that, and you'll be able to see all that great information. And the last thing is, I just mentioned it, next webcast for our monthly sales, quarterly sales forecast is on May 31st at 2 p.m. We'll be sending out the notice. You make sure you want to RSVP for that. So, but today we want to talk about liability. Every time you walk in and do PO purchase orders or do projects in your business, you open yourself up to tremendous potential risk if something goes wrong in the heat treating process. And the way that members are protecting themselves for years and decades has been the MTI statement of limited liability. So that's what we're going to be talking about today. So today we have with us someone who's done a lot of work with MTI, especially in our meetings format back in COVID, is Mr. Jeff Tenenbaum. Jeff, say hello to all of our members listening in.
Hey, everyone. Thanks for joining us here today.
So Jeff, so share a little bit about Jeff Tenenbaum and Tenenbaum Legal Group and what y'all do.
Okay, thanks, Tom. So I am an attorney in private practice in Washington, D.C. I've spent my whole 27-year legal career as an attorney in D.C. in private practice representing associations and other nonprofit organizations as outside counsel. For 20 years of my career, I was at a large law firm called Venable, chaired the nonprofit practice for most of that time there. A little over 3 years and a few months ago, started Tenenbaum Law Group with my colleague Nisha. We've now grown to be a 6-person attorney law firm that specializes exclusively in the representation of associations and nonprofits. And as Tom said, we've done work with MTI and many other similar associations. So the types of issues that we're going to be talking about here today are things that I work with other associations, actually working with another one right now on something very similar, and I've worked with hundreds, if not thousands, of associations over the years on similar issues. So hopefully that's a little helpful background for you.
Awesome. Thanks, Jeff. So just for members' clarification, if they have not, some may not be using the MTI statement of limited liability. Decades ago, the Metal Trading Institute designed a copyrighted statement of limited liability. It's one page, and it outlines the limits of liability that if you're doing business with a customer, if something goes wrong in the heat treating process, what you're liable for. And in our limited liability, it's 2 times the heat treat charges that you would have charged them as your maximum limit of out of pocket. Now, we did a survey a number of years ago, and just so you know, some members put that on the back of every purchase order. They have customers actually sign off on it once a year. Some will place it on their website and say that by doing business with us, you adhere to those limits of liability. But we're going to talk about those issues later on down the road. But you can get a copy of that in our resource library in the app, or you can email our offices at info@heattreat.net, and you can get a copy of that. It's all pre-done. You just put it right on your PO purchase order or put it on your website, however you want to disclose it. So Jeff, can you break down just limits of liability in general when it comes to legal law, 2 people doing business together, company to company? Can you break down what the statement of limit of liability is and how it works within a set of terms and conditions? Because terms and conditions in our membership, one heat treater might have just the statement of limited liability is its only terms and condition. I know others have like 18 terms and conditions, 6 or 7 pages. So break kind of that down and how that works out.
And so a statement of limited liability, some people refer to it as a disclaimer or a release. But what it essentially is, and a statement of limited liability is really the best thing to call it. So essentially, when You're a service provider. You're doing heat treatment. A customer comes to you, pays you to perform some service. If there's a a purchase order or a contract that says, I, the service provider, agree to do XYZ in terms of heat treating, you agree to pay us. Obviously, if you do what you say and you deliver it to them and they pay you, all well and good. But as we all know, sometimes in all sorts of provisions of products and services, including heat treatment, sometimes things can go wrong. There can be accidents. Products can break. Sometimes through no fault of your own. Sometimes through negligence, which is a form of tort liability, and sometimes as a result, I'm guessing not most of the time, if any of the time in your world, but sometimes through gross negligence or reckless conduct that causes some sort of injury. And if there's some sort of damage or injury to the product, the customer is going to want recourse, and they're going to want something from you that's more than just the dollar value of what they paid you to do the heat treatment. And so the idea behind the statement of limited liability is to say, when there's a contract between you and the customer, and even if it's just a purchase order, it's still a contract. Sometimes people think of a contract as, an 8 or 10 or more page document, but it doesn't have to. A contract is just any legally binding obligation. It can be something that someone signs. It can be a click and accept if it's done electronically. You're all familiar with things like DocuSign and other electronic mediums for entering into these agreements. But you're entering into a binding agreement with your customer. And the idea behind the statement of limited liability is to say that if something goes wrong, you, the customer, agree that you can come after us, but not for more than 2 times the dollar value that was paid to us from you. That's the maximum damages. It's called damages in tort liability and contract law. It's called damages. And basically the maximum damage is the maximum monetary amount that customer agrees maximum they can recover is 2 times the dollar value of what was paid. That's important because if that can be enforceable, and we're going to talk about that, but presuming it can be enforceable, that's generally going to be far less than, say, the cost of the damaged product. And so that can go a long way toward mitigating your liability risk for that damage. Now, it could be damage, it could be something wasn't done right. Maybe there was confusion in the instructions or whatever else. But let's just use kind of damage as a common example. And so in a situation like this, number one, we want to make sure that this is binding. And that Tom referred to, and in kind of preparing for this webinar, I talked through the kind of the various methods that you guys, that your members utilize as statement of liability. The key thing is that you want the customer to affirmatively agree that they will be bound by the terms of that statement of limited liability. And the more places, the more vehicles, the more locations where that happens, the better. So should you put it on your website? Absolutely. Assuming you have a website. Should you attach it to your purchase order and or other contracts that you use with your customers? Absolutely. Can you cross-reference it? So say, for instance, it's listed on your website, and say your purchase order is kind of a click and accept or a DocuSign or something like that. Can you say, but by agreeing to this purchase order, we agree to be bound by all the terms and conditions that are found at this link on our website, including, and I would call it out, the statement of limited liability, because I'll get to this in a minute, but what you want to do is be able to show that the customer knew that they were entering into this and agreeing to the terms of this statement of limited liability. So we want it to be very affirmative. And even if it's a click and accept and it's a link to the statement on your website, that's fine, so long as you're making clear that they are entering into this limitation. Sometimes these limitations on liability can get struck down by courts. So if a customer, has a product that gets damaged and they claim, the product was worth, I don't know, I really don't know the value of your product, but they say it was worth $5,000 and, the amount they were paying you was $500. and they sue you for $5,000, what we want to be able to do is make sure that the court will uphold that 2 times the cost limit that's imposed in that statement of limited liability. So how do you help ensure that it will be upheld by a court? Well, one is we want to be able to show that the customer absolutely knew what they were getting into. So it's not buried in the fine print. You want to kind of highlight it, make it bold. Ideally, the advice that we usually give with things like this is that you want them to kind of click and accept or sign this actual statement of limited liability. So there's no question that they saw it. It wasn't buried in 5 pages of other terms and conditions. Even if it was, it doesn't mean it'll necessarily be struck down by a court. But the more evidence you can show that the customer clearly knew about it, read it, was aware of it, the greater the chance the court will uphold it. Other reasons that statements of limited liability sometimes get struck down and disregarded by courts will be if you engage in gross negligence or reckless misconduct. In those kind of situations, no statement of liability is going to protect you. But if it was a simple accident, if it was simple negligence, but especially if it was just an accident, there's going to be a greater likelihood that the court will uphold that statement of limited liability.
So Jeff, now the terms and conditions, like I said earlier, some are like 7 or 8 pages, some are just this 1 page, but over and above the terms and conditions and the statement of limited liability, what are some other key elements you think people need to make sure they think through about what's in their terms and conditions so it's really comprehensive and they're really well protected?
Yeah, it's a great question. So first off, remember, I'm going to repeat it again, what I said, in that you want the customer to very clearly be aware that they are agreeing to the statement of limited liability. So even if you have other terms and conditions, and I'm going to talk now about some other terms and conditions that I think are very important as well, at the same time, you want to make sure you kind of call this out, put it in bigger print, put it in bold. If you have an ability to have them signed separately, like a separate signature line or a separate click and accept that they agree to the statement of limited liability, in addition to your other terms and conditions, I would strongly recommend that. But beyond that, there are other important things that you really should have in your contracts with your client. And it could be, styled as a purchase order, that's fine, but you want to have other terms and conditions. If you just have, we're going to do this service, you're going to pay us this, and here's our statement of limited liability. There's a lot of other things that are missing. And I've reviewed some kind of sample actually in the MTI statement of limited liability reference guide, which I guess is in that resource section of your site that you talked about, Tom.
It is.
There are actually a number of really good suggested terms and conditions. It's called List of Optional Terms of Sale. And this is all really important stuff. It looks like it's about 7 pages. It includes the statement of limited liability, which is about 2 pages of those 7. But the rest are things like, details about the price, details about variation, delay, and cancellation, certainly the payment terms. And for instance, on payment terms, it has something in there that says, if you don't pay us the full amount or you didn't pay us on time, we can go after you in terms of collections, and you agree to pay all of our costs in collecting. If you have to hire an attorney or something like that to go after them, they agree to pay your costs. If you don't have that in your terms and conditions, a court might or might not award attorney's fees, but you're going to be in a much better situation if you have it in there. There's details about pre-delivery inspection and tests, about delivery itself, passing of risk and property, inspection of the service materials, confidentiality and intellectual property rights, and then a few other things that are important: excusable delays on your part, indemnity by the buyer, meaning they agree to indemnify you, to hold you harmless, to pay your legal fees and any judgments or settlements against you if anything bad happens to your people as a result of their deficient product that they send to you. There's an insurance requirement that they have to, and this might be a bit much, but it's up to you in terms of what your customers might push back on. But it says they have to maintain commercial general liability insurance and no less than $1 million in annual coverage. There is a law and a choice of law and venue provision, meaning if you end up having to litigate the matter, that the litigation will occur in the courts of your primary state, your home state, and what can only be litigated in that state. Very important. There's a mandatory arbitration clause. And those are the primary things. But, you know, these are really important clauses, and I'm not trying, just because I'm a lawyer, I don't think I'm trying to over lawyer things or make it too complicated, but they're really all important things. The way that so many things can be done electronically these days, most people are never going to read, most customers are never going to read through that. You know that. But I think they're all really good things to include. But again, I would really make sure that you have a separate affirmative acceptance of the statement of limited liability.
So none of this stuff is a good friend of mine once said, everything's funny when you're making money, right? So no one ever has to pull out the statement of liability and or a contract until the deal goes south, correct? I mean, when everything's being done right, everything's being processed right, the parts are coming in right, no one ever really questions anything. Everything's good. It's only when that part is not good or processed bad, all of a sudden they pull out the legal lawsuit and said, hey, Jeff, you know, we want to sue you for $80,000 because that's what the parts were worth. And you're like, no, the heat treat charges were 10 grand, max you can do it is 20 grand. So I think that's what's important about walking through these is understanding what is your risk of not, which leads us to the next question. So what happens if a heat treater has got no limited liability statement attached to their purchase orders at all? They're just kind of, not only say flying by the seat of their pants, but they're not having that limits liability. What could happen?
Yeah, I mean, they would be able to say some damage occurs to the part, the product. They are likely going to try to hold you liable for the full fair market value of that part. That's going to be typically a lot higher than what they're paying you for the heat treatment. And they might even be able to hold you liable for other things like consequential damages, like say they needed that part for something else and that caused them to lose out on some business opportunity, you know, the subsequent liabilities that can result. They can hold you liable potentially for all of that. And so this is really important to help mitigate that liability risk.
So no one ever wants to go to court, but what does a heat treater do? If a customer comes at them and says, hey, look, 2 times is not enough. I know we signed the agreement, and they're, especially if they're a good customer, I mean, what should be the steps that a heat treater takes if they're approached and a process goes bad and the customer's really pushing back on them on this thing?
Yeah, it's like everything else. Just earlier today, I was on the phone with another attorney to try to negotiate a severance agreement for an executive, right? And he's coming at it from one perspective. He's offering a certain amount. My client wants more money than that. And the benchmark that we're looking at is the contract, the employment contract. You know, what does the contract say that my client would have gotten in a termination without cause, that sort of thing. So what's in the contract really matters because it kind of level sets and it sets the beginning part of it. It kind of sets the grounds, the boundaries of the negotiation. Right. And especially if it's a good customer. I mean, sometimes the relationships just go really south and then it gets ugly. But whether it's that situation or with a good customer, frankly, either way, you know, you're going to start the negotiation at 2 times what they paid. Now, if you really did screw up, and they're threatening, and their attorneys tell them that this statement of limited liability is not going to hold up if it goes to court, you might end up deciding to pay a little bit more. You might decide, you know, to pay 3 times the amount of what they paid, or even 4 times. But if you have nothing in there, you know, you're going to go from numbers that are down here to likely numbers that are way up there. Right. So it helps to make for a more amicable negotiation, and it helps to kind of level set and give you a better starting point in that negotiation.
You know, you just said the key 2 words, starting point. We did a survey probably 5 years ago on the statement of limited liability. And we asked members a couple of questions. One, do you use it? If you do use it, has it ever been challenged? And what has been the outcome? And what most members said was that, yes, numerous members have been challenged because obviously heat treating is not perfect all the time. A part gets damaged and, you know, something happens and you got to pull out the statement of limited liability. And all of them said that they were never asked to pay. Legally, they were never asked to pay more, but was the starting point, because if it's a good customer that's giving you millions of dollars of business, and this is a $100,000 deal, what they said in the surveys was that they found the medium ground where they were willing to pay the customer more than the 2 times, and the customer wasn't exactly pleased, but they were happy with the outcome. Everybody kind of gritted their teeth and got a little bit out of it. So I think that's the key, is it starts you at a much lower level to start to negotiate than if you were to start with no limited liability and you're starting from way up here. I think that's the starting point. I think is the key word that you mentioned there.
Absolutely. And, and if it gets upheld in court, you're only going to have to pay 2 times,
Right.
which is really important.
Well, and as you say that, I think on the other side of the fence, it's a good way to get rid of a bad customer, because if you just hold them to that 2 times and they're a big pain in the butt customer, they're probably going to walk away from it. So it's an opportunity to have a customer walk away that you probably don't want to do business with as well.
Yeah.
So kind of in summation, I mean, the good news about a statement of limited liability is it's pretty concrete and pretty simple. You want to have it everywhere. You want to have it on your website. You want to have them affirmatively sign off on it in some capacity where they click through and say they understand it, but they must have read it so they can be able to do that and it uphold in court. I would recommend members, you can go to our website. If you go to our website and log into the members only area and go to the resource library, you can look up, just type in liability and the statement of limited liability link will pop up and you can download it. It's a 1-page PDF file that you can download, and you can have your printer put them on your invoices anywhere. If you for some reason can't find it, you just email our offices at info@heattreat.net and we'll get you that statement of limited liability as quickly as you ask for. It's a 1-page document, pretty quick.
Yeah, and one thing, Tom, I want to point out, if those of you might be able to see it, is that unlike the rest of the terms and conditions, this kind of model terms and conditions that you have, the limited statement of limited liability is in all caps. And sometimes you see that in contracts or, terms and conditions of purchase orders, and you may not know what that means, but it's for the same reason I just said, that we're trying to really emphasize that there's no way that the customer missed this.
Right.
And buried in the fine print, it's literally in all caps. Like I said, if you can have a separate, where they have to initial or signature that they read that, if it's online, have a separate click and accept, even better. It's just going to strengthen your argument in the end, which is going to make it more likely it'll get held up in court if it gets litigated, and it's going to strengthen your hand in any negotiations.
Yeah, and I think the key behind our statement, Jeff, is it's that we built it like this for a reason. It's only 1 page. It's not like some of those things that you get that's 22 pages and you just scroll through it because it's so long and you don't read it. This is a simple read. It's powerful. It's to the point, and it really does. The biggest case we've ever had so far that came out of I think it was the early 2000s, was we had a member that was sued for $5 million over this exact thing. Sued for $5 million because a part went bad south, and the courts held up the statement, and they only had to pay 2 times, which was way less. Now, what they would tell you is that it took $250,000 of their own money to defend it, but 250 versus 5 million is way less. And I guess, and I made the comment in our earlier conversation, Jeff, that, well, insurance may or may not have paid for that defense, but if you could just kind of touch on a little bit about, the insurance aspect of if you get sued like that, if insurance may or may not cover it.
Yeah. So first off, insurance is really important, right? Insurance is designed to cover all sorts of risks that are foreseeable, but that might happen. And there's all different types of insurance. Your own businesses, I'm sure you have commercial general liability insurance. I'm sure you have property insurance. If you do anything, online, you need to have cyber insurance these days. There are other types of insurance, employee dishonesty bonds. Nonprofit organizations like MTI have directors and officers liability insurance. Sometimes they have errors and omissions insurance. And the reason there's different types is that different insurance cover different things, and there's always exclusions. Every insurance policy has a whole bunch of exclusions. So generally, and I am not an expert in insurance for your world, but I can speak more generally, from all of my insurance experience with associations and nonprofits, is that, like, at least in the nonprofit world, you can't get any insurance. Well, one exception being like meeting insurance for meetings and conferences. But other than that, you can't get insurance for breach of contract. So these types of insurance are called liability insurance policies. And that means basically someone sues you for something that you did intentionally, or you did wrong, or you were negligent. If you intentionally breach a contract, or even negligently breach a contract, you're generally not going to be able to get insurance for that. But if someone files a claim that you were negligent in how you perform the services, you should have, and I'm guessing that all of your companies have, one of those forms of insurance will cover negligent delivery of a service. And so it really just depends on the nature of the claims that are filed. That dictates whether or not there's going to be coverage or not. So there may be coverage, but if someone just sued you for breach of contract, there might not be. But either way, whether you have insurance or not. Again, this is really important because the insurance carrier, if they see there was a clear disclosed statement of limited liability, the customer clearly read it separately, clicked and accept or signed that they saw it and they agreed to it, it's well drafted, it's not overly broad, it's actually very well drafted. Then it's much more likely that the insurance company will be able to settle that. The insurance company appointed lawyers will be able to settle that for a much lower dollar amount, which will help you in the end in terms of your premiums as well.
Awesome. Well, Jeff, any final last words as a legal expert on anything related to that you haven't said yet?
No, I mean, just in closing, you don't need to understand all of the legal aspects of it. It's a lot of legalese. But being someone who drafts these kind of things and reads them and negotiates them all the time, it's very well drafted from a legal perspective. Sometimes these sorts of statements of limited liability are overly broad or unreasonably broad or things like that. And it's not. And so you don't need to do anything to it. You don't need to change it. I would recommend that if what you utilize right now is just a real bare bones purchase order and your statement of limited liability, that you consider adding some of those other MTI suggested terms and conditions. I strongly recommend that. But this is all kind of best practices, and you really want to get your legal documentation, your contracts into really good shape, make sure they're clear, there's clear acceptance by the other party, and it's really going to help protect your company and put you in a lot better financial and legal situation if and when something goes wrong. And it always does.
That's for sure. It does. Nothing's ever perfect long term. So Jeff, thank you for that today. And members, I just want to let you know, so remember, this is only a one-page document. It's been looked at by legal teams for decades for MTI members, solely for us. It's you get it as free as a member benefit. And I would suggest that you go out to the website and log in and go to the resource library and look up liability, and you'll see it pop up, and you can download the PDF form to be able to put it in your documentation, as well as the reference document that Jeff was referring to is a best practices document that the legal team that looked at it last time put together for us. You can reference that and see all those terms and conditions in there. So, but anything else, if you need anything on that, you can always email me directly, tom@heattreat.net, or our general email at info@heattreat.net, and we'll get that information to you so you can take care and help protect your bottom line. So Jeff, thank you so much today. And members, we'll see you next time on MTI TV.